You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. I've got some of your comments. Let's start with this other matter from the Supreme Court, and I'll read your comments here. Okay, let me read just a few. Musa Abator in Kumasi says, Kweku Bako. What are you saying? Yes, Kweku Bako has done what? Kweku Bako should deal with Woyome as individual, not trying to pitch him or pitch him into his NDC argument, because it was AG Maretta Brew appear upon under the command of ex-President Mahama, who initiated the move to retrieve the money for the for the state. Okay, the facts, people get them mixed up all the time. Iliasu in Tamale says Woyome didn't pay himself those monies, hence the need for the security to go after former government officials complicit. The ruling at the Africa court is the end of the road for Woyome. Spike in Cincinnati, he says that every Ghanaian should be joyous now. At long last, the battle has ended. Every dime should be retrieved from Woyome to the state. Eja Adam says the Woyome scandal, which tormented the NDC for years, has reached a state where one could say it is coming to a successful end. Suit for this government. The Woyome case would have, for this government, the Woyome case would have screeched to a jarring halt without any concrete outcome. Okay, thanks for those messages. I'll read some more later. But the Supreme Court once again did something. And I just got a disclosure. I didn't know about those facts, because when you read the judgment, all of it, you don't find in the 26th page, you don't find that aspect in it. But the lawyer who led it, Eduji Tamaklo, told me about how at a point they felt they should even withdraw this case, and because they filed it in 2017. February. Yes, and so sometimes you may get some fatigue. So they wanted to withdraw it. January 4th, right? Yes, and go to sleep.
2017.
Yes. And when they made the attempt, the Supreme Court said, it is your case, but we won't allow you to withdraw it. Keep it here. We will deal with this matter. That is a very strange, somewhat, quote-unquote, strange attitude of the court. Because when you take your case to the court and you say, I'm no longer interested, they willingly ask you to do what? Remove the case.
But
what is your reading?
On my show, he gave a reason.
Yes. Public interest.
Yes, he says that the Supreme Court told them that one of the reasons they've cited for their suit was public interest.
Right.
And so in view of that public interest and the fact that the decision of that case transcends beyond
the two of them.
Yes. So then they should still go ahead and do with it.
Great. So,
but whether it is regular and normal for the Supreme Court to take a decision on this matter after 2.5 years is something that I don't know. I don't go to the court, so the three of you.
No, that's okay. Yes, that's really okay. Yes. So, what do you say, Theophilus Donko, who was the plaintiff, and the lawyer Eduji Tamaklo? So, what do you say about the Supreme Court's attitude to the suit itself and the conclusion it has reached?
Well, I think that basically the Supreme Court's attitude was well founded. Great. Because this is a matter of national interest, has been carrying our political history for far too long. In fact, the starting point, if you want, will be Salah and the Attorney General. Clearly. I mean, where about 568 people were dismissed because they were occupying various offices in public office. I mean, when Buzia took over the reins of this country. That decision itself of Salah was challenged. Okay? Now, we've had, I represented Shelley
Ayoko.
No.
Okay.
Shelley Aite.
Okay.
When she was asked to proceed on leave.
Sherry,
when she was then working with Ghana Johok distilleries. I mean, we went to court, and the court said, yeah. I mean, the challenge to the suit was that we had not given them notice consistent with State Proceedings Act 555, Section 10 of that act. That requires that 30 days notice. But we drew their attention to the fact that that letter, that asked her to proceed on leave, was a human rights matter, okay, and that decision to proceed on leave originated from Article 23 or so of the Constitution, which is an administrative decision. And so that being so, and Article 23 being part of the provisions of the fundamental human rights, chapter 5 of the Constitution, we were entitled to come under the exceptions of the under the State Proceedings Act and sue without giving notice. And so and Apollo said, yes, you are right. You are perfectly right. And so the matter continued. She finally, just like all others who initially thought of going to court and vindicating their right, she finally asked that we abandon the matter. After all, she was not going to get anything. Then we had Hudare Okine, who again occupying the public office, was somehow had done by decisions of government and went to court.
He was reassigned.
Yes, he was reassigned. The reassignment was construed
as a demotion.
As a demotion.
Constructive dismissal.
That was
the case. And so, and Article 191 clearly B talks about that. He was clearly covered.
Okay, so help our viewers.
Yes.
When Kweku said constructive dismissal, all of you agreed. What does it mean in law, constructive dismissal?
Well, when you take all the circumstances into consideration, you come to the conclusion that this is a dismissal.
You have actually not been sacked or dismissed.
But the circumstances,
okay, will show that it is intended to dismiss you. Okay, so proceed. Let's come to this one.
And this one. And again, you know, as a politician, we'll say that when His Excellency Nana Addo Dankwa Akufo-Addo assumed the reins of government, many civil society organizations have complained. The politicization of the public service. That many people have had to go just by reason that they were appointed by the previous administration. But how did we come to where we are? We came to where we are because civil society organizations led by IEA came to the conclusion that what was happening to the public sector and public service officers was not the right way to go. And that in their view, it was important to delimit, identify, categorize, and spell out offices which will have to go consistent with the tenure of the president. And that was captured in Section 14 of the Presidential Transition Act. Okay. 2012. And so, yes, so I remember clearly Marita Brew saying, well, so what does this act actually tell us? Even at that point, she had great difficulties understanding what Section 14 of the Presidential Transition Act was all about. Because clearly, there were certain people who were insulated against political manipulation under their terms of office, but who had to go because they were simply appointed by the... I think that this decision of the Supreme Court is trying to do is to bring some clarity to persons who must go, and also give effect to the intendment of the Article 191 of the Constitution, which is protection of public officers, and also insulate public officers of a certain category against political manipulation. And that all of us, and it's good, public officers must have some level of security of tenure. That when you are appointed into public office, you serve the public and not the government. And that people must look beyond the appointing authority for the one. That is why the Constitution has clearly given instances where a public officer can be dismissed. Okay? And that there is it is not just cause to say that by reason of a change of government, you must go. That's basically the decision of the court. That in some category of public officers, it is definitely not just cause to say that because there's a change of government, you are also changed. And so I think that is a very good development. It's a restatement of the Sala and the Attorney General, and a culmination of all the matters that the court has had to deal with in persons who have to suffer changes or dismissals or promotions or demotions by reason of changes in government.
Okay, let me find out.
It also consolidates our credentials as wanting to establish on firm ground rule of law in this country. That people can just not, cannot be dealt with impunity. And so executive impunity, if you want, is being held in check here.
Right. Now, Dr. Tupare, there are those who have, you know, an understanding that it's sort of a wholesale thing. Every CEO is secured. Once, you know, you are named as a CEO, you will not be dismissed if a new government comes in. And if you belong to a board, you may not be dismissed. Is that exactly what the Supreme Court said? What exactly did he say? Who can the president, or can the president not, you know, remove as a result of change of government?
Thank you. First of all, I think we need to thank, we need to congratulate the plaintiff and the lawyer in this case, who has taken out the rate to be able to test the law and to bring some clarity to the law for us in the Republic of Ghana. That's very, very important, because sometimes some people would say go, others would say don't go, and if you listen to the voice of don't go, then we get the law increasingly strengthened, and we are not getting the development of that law. So the Plaintiff and the Lawyers Act amounts to a very useful public reading of the Constitution, and the court actually provides that platform. So the court becomes an avenue to develop the law. So we're very grateful for that. Now, to understand this, I think that some people wanted to maintain some kind of slavish attachment to Section 14 of the Presidential Transitional Act, which is Act 845. And in other case, that let's have some kind of fixation, and it's a restrictive fixation that all officers who fall under the Schedule 2, Section 14 must go upon the assumption of office by the president. So in this case, it gives the president a wide power to dismiss or to cause to be removed everybody who falls under that. And if you look at Section 6, Section 14, the schedule, it includes officers that are appointed to the governing bodies of public corporations and what have you. So
let's do the list so that it helps everybody.
Okay.
So number one, persons holding office under the Presidential Office Act. The people that recently the names came out, there were about how many? Almost 1,099, was it? Everybody was complaining. Is it 900 or something?
998.
Right, 998. The people who work around the presidency, they are all appointed by the president, so to speak. So the law says all those people, when a new president is elected, not new government, new president comes into office, you must go. Number two,
but
ministers,
be
deputy
careful.
ministers,
Just
and
a
deputy
moment.
ministers
But
of
be
state.
careful. That huge number.
Yes.
Quite a lot of them
Yeah.
are already in the public service.
Right.
Yeah,
That understanding
They,
is there.
in fact, if
Right.
you check the list, have been recycled
Right.
over the
Right.
years. Yeah.
Then number two is ministers and deputy ministers of states. That's very obvious, isn't it? Number three, regional and deputy regional ministers of state. You must all go when the new president comes. Special assistants, special aides to the president, to the vice president, and to the ministers of state, deputy ministers, regional ministers, and deputy regional ministers. Number five, non-career ambassadors and high commissioners. Number six, persons appointed by the president or a minister of state as members of statutory boards and corporations. So all persons under this list were supposed to go immediately a new president comes in. Now, that's no more the case, correct?
We, correct and not correct, that we were making reference to the 6 of the schedules. I think that was the contention before the court. And to deal with these analysis, it's important to refer to the memo. The memo that was attached to the bill, which is now law and which is now Act 845, whether that memo, which was submitted pursuant to Article 106 of our Constitution, which is that a bill before Parliament must be accompanied by a memorandum, and that the memorandum should spell out the policy rationale, the defects in the existing law, and the remedies that are contemplated to deal with that. So you must understand what were the defects that occasioned the presentation of this bill to Parliament. And of course, the overall, let's say the core claim of that memo, is captured by the preamble. That is the bill to deal with arrangements for a political transition. That is how to transit power from a democratically elected government to another. It has nothing to do with an open compass for the president to reach out to all public officers and cause them to be removed. And I think that is where I agree with Honorable to the extent of the effect of the judgment of the Supreme Court. Because in this case, the Supreme Court is very clear in dealing with two modes of appointment. Appointments pursuant to Article 70, where we're talking about the president's power to appoint chairman and other members of the governing bodies of public operations, and then appointments that are envisaged under Article 195, where we're dealing with permanent staff. And if you look at the two modes of appointment, they're different. In the case of Article 70, is the president in consultation with Council of State and on the advice of the governing board. That is the procedure. In terms of Article 195, it is the president with the governing board plus the Public Service Commission. So these two modes.
And the president must even act in accordance with the advice of the governing board.
Yeah. So the two are not the same.
Yeah.
Now, the take of the court is that you should distinguish non-carrier people who occupy certain places in the public service from permanent staff who occupy places in the public service. And then the non-carrier people is the subject matter of the court ruling. It is not a wholesale ruling that all public officers are in that particular category. And that's very important to understand why Article 191, where we have this just clause, you can be dismissed or be removed from power with a just cause. So the just cause is attached to those who are under 195, and these are the permanent staff that we're dealing with. So the just cause is not referable to the Article 70 appointees, who are the non-carrier people and who are actually the subject matter of the court restrictive interpretation in reference to 6 of the schedule of section 14. So the fixation that it is, all of us, whether it's public office, I shouldn't say whether, all of us under 6 are public officers. Therefore, the just cause clause must apply to us, is what the court has refused. Now, in dealing with this thing, the most important thing...
The language it's used is that to the extent that Section 14 of the Presidential Transition Act 2012 requires chief executives or directors general, howsoever described, of public boards or corporations to cease to hold office upon the assumption of office by a person elected as President of the Republic of Ghana, the same is hereby declared to be unconstitutional and void for being in contravention of Article 190 and 191 of the Constitution.
Agree. That is, you should understand that in context. That is, if you want to read that all public officers or permanent staff within the public service, as contemplated under Article 190, Article 1901B, you will have a problem. So there should be a distinction between Article 70 appointees and then Article 1901B appointees. So to the extent that the non-staff are part of that conception, then you are correct. To the extent that you lump all of them together, then you're going to have a problem. And we must distinguish this, that even the mode of appointment to the governing bodies or the composition, tenure, removal, and what have you of some of these governing bodies, you have to take that into account because they have what we call constitutive acts.
Right.
And then you understand that in the unanimous voice of the court, they actually demonstrated the distinction in some of these. For instance, University of Ghana, yes, Act U, the Foresters Commission, and what have you.
So explain what the demonstration meant. What did they say? Like University of Ghana, who can the president deal with and who may he not be able to deal with?
The president can deal with those that are the subject matter of Article 8, Article 70, which he has sent there. But if you look at the composition of the University of
So
Ghana's
the president can deal with those he appointed onto the board.
yes.
But
The
those
president
who were appointed by UTAG or the others, he
exactly
cannot touch them.
cannot, because yes, it is explained that these ones are sent by constituencies. They're representatives from constituencies, and by virtue of those constituencies, then they are coming to the board.
Okay.
It has nothing to do with the president, and that is why the court is clear that those guys can really be removed by reference to the bodies that send them, and by reference to the Constitutive Act, which is the law which is setting up the entity that we are dealing with. So the universalization of all of them being on the board are the appointees of the president is not correct. So we need to be able to distinguish that. And if you distinguish that and even go to the Constitutive Act, you will see that some of them have indicated when you should vacate post. Some of them have indicated the tenure. It has to be 2 years. Some, it has to be 3 years. So even, it has nothing to do with the president.
Okay.
And it has nothing to do with whether or not the president has come into force or not. So the relevance of this case for me is actually the unanimous voice of the country, the court of our country, and the verification of this understanding, permanent staff and non-staff, which is that the good cause is attached to the permanent staff of the public service. In that case, there is room for us to consider due process. There is room for us to talk about rule of law. There's room for us to say that you cannot just be removed from office without recourse to the law. And that it also sanitizes the transition terrain for the actors, particularly the politicians, the observers, voters, and the international community, because sometimes we are at a loss as to who is going to go, who is the subject matter of Section 14(6), and who is not the subject matter of that. Therefore, it eases tension and desperation, because sometimes people are saying, I'm going to go. Others will say, you are not going to go. You're not one of those that we are contemplating. So it's very clear. So there's some certainty and predictability of whether or not you're going or whether or not you're not going. And that you cannot destabilize yourself in terms of your thoughts if you do so. And it brings about stability and faith to the core objective of the act itself. And the core objective of the act is actually to deal with political matters. It's not just to deal with, change of office and then change of office of public officers.
Answer this very briefly in 1 minute. How much has the president's hands been tied, a president's hands been tied as regards who he can sack and who he cannot sack once he assumes office?
In the case of this, the Section 6 that we have referred to, the CEOs, the chief executive officers and the director generals, those are what we call negative. That is, the president must stay hands off. They are just members of the governing board by virtue of their position in such entities.
Okay.
It is not the fact that the president has appointed them. So the president must stay hands off. But those who have been sent there by the previous government, by virtue of being president's nominees, and what have you, the court is clear that we will not want to be saddled by people who might not believe in the cause of the president. Those are the people that we're dealing with, and those who are the subject matter of Article 70, not everybody.
Okay, so Randy, what's your appreciation of what has happened?
Well,
and what are the implications long term?
well, Samson, I'm extremely excited about this particular case because I have been a strong advocate for good corporate governance and the respect for law as far as the exercise of the powers of the executive has been. So I'd like to congratulate Theodore and Godwin Eduji Tamaklo for this initiative. Although I appreciate that they went to court at a time when they expected the Supreme Court to have made a pronouncement around that time. If you look at the timing of the suit, 4th of January, and that is when the transition was ongoing, and there were a lot of things happening and threats and all that. And so they expected the Supreme Court to have made a pronouncement around that time.
You mean those who were going to suffer have already suffered?
Yeah, to avert what happened with a change in government. Unfortunately, it didn't happen, and I'm sure that's why they decided to discontinue the case, because they thought that, well, by virtue of time, what they sought to achieve had been
The
defeated.
political readers actually say that this will protect, say if it happened that John Mahama won in 2020, this is to protect some of the appointees of President Akufo-Addo.
Well, I've heard that, but you know, my reading, you know, you asked Doc a question, how this ties the hands of the president. I do not see the president's hands being tied.
Okay.
I see this as telling any president that do the right thing. You have the powers to do things, but do it in conformity with the law and good corporate governance practice. It's as simple as that. Now, when I look at this issue, you have issues of, one of the things that I was wondering was, how come this escaped everybody? I mean,
Did it? No, it didn't.
if it didn't, it wouldn't have become law.
No, it has never escaped anybody.
So how did it become law?
Okujato went to court and challenged the power of the president to remove him from the Bank of Ghana.
No, you don't get me. I'm saying
yes,
the question I
it is.
ask. I'm not saying that. The question I ask is how this got to be part of the Transition Act, the presidential transition. That's the point I'm making.
Those specific areas.
Yes, okay.
No,
okay.
the area
That
that the
particular
Supreme
sex.
Court,
Struck
the
down.
section 14.
Right.
That's 6, yeah.
Yes,
but
the
it wasn't
46.
the entire
No, the 6.
The
The
six.
fourth, yeah, the six.
Yes.
How that escaped everybody is what I have been thinking about.
Yeah,
That
okay.
for all this period, granted that in 2012, it was one administration succeeding itself. So you didn't have some of those tensions. But how he escaped everybody until Theodore and Godwin went to court beats my imagination. But thankfully,
He refers to Samakujeto's suit when President
Bank of
Mills,
Ghana.
President Mills
Yes.
removed him,
Yes.
or sought to remove him.
Yes.
But he took that on his personal level.
Exactly.
Level, yes.
This one is to everybody,
Yeah,
so
yeah.
to
Right,
speak.
looking at the
But-
constitutionality.
Yes.
You
of
are
otherwise
looking
of
at,
that.
no. What I'm saying is
substance.
that I'm saying that people have always challenged the power of the president so to remove.
Okay.
I get that point.
Yes,
but the
yes.
point, what I'm alluding to is how this got to be part of the Transition Act and how come it's remained so for close to 5 years.
Yes. Okay.
That's what I was wondering. Because
Okay.
even Dr. Anaba,
Anaba.
Ridge Hospital,
Yes.
he contested, he
Yes,
lost,
yes.
he's on appeal.
Yes.
But he lost.
Yes. Yes.
He lost.
Well, for
He's on
challenges.
appeal now.
Yes.
But you know, this one is actually challenging what is in the Transition Act, what has been accepted as law.
Law. Yeah.
And that's what makes it different. You know, and that's why I say I'm wondering how come nobody could see the unconstitutionality in this thing until now. So I appreciate the two gentlemen, Theodore and his lawyer, Godwin Edugitamaklo, for what they've done. Because
two lawyers, one acting as
yes,
lawyer for him.
yes, it goes to help us to do the right thing.
Yeah.
Because I've had cause to speak about this severally.
Okay.
Look, at the heart of all of this, you know, this had to do with dismissals. But if you look at it, the effect really is also about appointments.
Yeah.
Appointments to these same institutions has been bastardized by political leadership for a very, very long time. You know, and one clear thing is that the Supreme Court didn't agree with the two gentlemen on all the issues they raised. On the issue of governing boards, the Supreme Court disagreed with them. Because the Supreme Court's decision in this matter was that the members of the governing boards cannot be said to be public office holders or something to that effect. They're not part of the people you bring under the Public Services Commission. You know, so for them, you cannot say that they cannot be removed upon the assumption of office. And then it makes a clear distinction between public corporations and then limited liability.
So this is what they said. They said members of governing boards,
Right.
of statutory boards,
Right.
and corporations appointed in accordance with Article 70. Doc mentioned that earlier, 71, D and III of the Constitution are not members of the public service.
Yes.
And their tenure is not governed by Article 191 and 195 of the Constitution. Therefore, each person may be removed at will by the president.
Right. So that's clearly something that the Supreme Court disagreed with the plaintiffs on. But it also brings clarity as to what can be done and what cannot be done. I look at all these things and it's just saying that, look, this is the right way. This is the most appropriate way to do things. Recently, there was a discussion, we had a discussion, you know, when the ADB issues came, when there was no board in place, and then the finance minister gave an approval for a loan, and government is only just one of the shareholders, and the issue of whether that action was correct, was appropriate or inappropriate came up strongly, you know, and obviously people were not following what was lawful and what conformed to good corporate governance. You get what I'm saying? And the issue has gone so bad that, I mean, in recent times, we've even had the president getting involved with middle level management. If you take the Ghana gas case, for a public affairs manager, and then you have the office of a president, a body that is supposed to have a board, and the board is supposed to deal with these things. And then you have a letter from the president asking the board to appoint somebody in a middle level management position. That's how low, I mean, we got to. This issue of governments not putting boards in place, and then people are appointed as acting chief executives, and then the boards are constituted later, and the board's hands are virtually tied. So all they have to do is to then, I mean, give some legality to those appointments, because in most cases, those who have been appointed as acting chief executives by the president get confirmed when the boards are subsequently put in place. What stops us from doing the right thing? Put the governing boards in place and let the governing boards go through due process and appoint the CEOs and all those other top officials. But what we do is that we do the reverse. The presidency and government will then appoint the CEOs and others, and then the boards are constituted later. And then the boards will then have to ratify these appointments that have been done.
Okay.
Look, one of the things that also brings a lot of controversy in these issues, and why I am sure they put it in the transition act, is that many of the people who are appointed to these public corporations and others are political actors. They are known political actors.
Right.
You know, so you see a certain difficulty when there's a new government in place, and they know that this is a political actor. The person is a visible politician. The person is an active politician. And the person got that appointment on the basis of their political affiliation. And yet, I have to work with them. That's the difficulty.
Right.
You know, and there is one thing, I don't know if I should try and get a lawyer, maybe you, to take me to the Supreme Court to deal with, which I think is also linked with this. Look, something I consider an abuse of the part of the Constitution that gives the president the right to give people above 60, people who have reached retirement age, a contract. As to whether the intent of the law is for people holding office. So, a specific example. For example, a managing director who attains 60. If it is the intention of the framers of that particular constitution, that look, for such a person, you could give the person a contract, not exceeding maybe 5 years.
Article 199
right.
says that once their tenure, they attain 60 years, they are supposed to go on compulsory retirement.
Yes.
However, depending on the exigencies,
yes,
if there is need for them,
yes,
you can retain them for 2 years, 2 years, and not more than 5 years.
So here comes.
Under contract.
So here comes where.
What's your problem?
I talk about that. Here, this is where here comes what I think is the abuse, and what I am saying that maybe I need to proceed to the Supreme Court. My understanding, and I accept the fact that I'm a lay person when it comes to the law. My understanding is that this is applicable to people who are in office and have attained the age of 60. But what we are seeing in practice is that the presidency and government brings people from outside who are over 60 and appoints them to head these institutions under this 199.
Do you understand him?
I understand him perfectly. I agree with you.
There are people who are, say, like 70, and they left public office at 60, like maybe 10 years ago.
I agree
and
entirely with you.
They are now being brought in and giving a contract.
So it appears from the
Constitution does not say. The Constitution does not say it should be a continuum. That immediately you retire, then you take the job, or that once you have attained 65, you know, you cannot be brought in.
That's what I'm saying is that
No,
political leadership.
I'm asking you,
the
I'm asking you a
Constitution
question.
is quite clear on the total reading of Article 99 of the Constitution. And mind you, what we are talking about, the extensions, were a subject matter of an amendment to the Constitution that brought in the clause 4 of Article 99. Article 99 had ended at clause 3. It appears from the reading of Article 99 that the person must mandatorily retire from the public service at 65. Mandatorily.
Yes.
Okay?
That's not in contention. So what's the point?
That's the point.
But you
So,
see,
so you see, it means that a person who is above 65 should not find space within the public service.
so there are two issues here. What he
The
raises
Constitution
about
doesn't say that. You are interpreting, right?
Well,
You are interpreting. It doesn't
I'm
say that.
interpreting the first of all, the Constitution says that a person must go at 60.
Right.
That's what the Constitution says. Now, if there are exigencies, and that's where I also agree with you, the exigencies must be because of the competence.
Yeah, you almost confused me. It's 199, not 99.
199,
Yes.
1994.
Yes.
Okay. The exigencies here must be interpreted to mean the competences. If it is difficult to replace the retiring officer by virtue of the competences that he has, then you extend his stay in the office for 2 years, 2 years, and 1 year.
So Randy may attempt his
So the point I'm
experiment
making-
and let's see how it goes.
Yeah, the point I'm making is that
yes,
what we keep doing is that we then have interpreted this to mean that I can go and take a 64-year-old who perhaps has never been part of this establishment and come and appoint him as CEO.
Yes.
You know?
If that falls within the exigency.
No, after
but
64.
is it not a
in
natural
that-
interpretation that should be expected on the provision when it says you attain 60,
Yeah.
And
you
go.
retire compulsorily,
Yeah.
but
Yeah.
if the exigency demands,
Yeah.
you should stay
You
back.
should be retained.
You see, that also is an interpretation that we are talking about that very person and that very institution.
Yes.
Whether or not you are talking about that very office and a person on account of the exigency of an institution can be brought there even though he has retired from the public service. So if the retirement within the public service is fixed at 60, which is compulsory, and then within public service and with your experience as a public servant, you can't, within the exigency of an existing institution, can be appointed. That is the controversy that is being brought, because you've been brought from outside. Should that be considered? Now, that point is different from where the person is above 70 and is being brought in. That distinction ought to be made. And we have to interrogate that very well.
let's hear.
For the 70
Okay, so let's not change the topic.
for the 70
Let's not change the topic. Let's get people to say
So in summary,
to speak on this. Yeah.
my understanding of this
Yes.
is that the Supreme Court is not taking any power away from any president. All it is saying is that do things the right way, in conformity with the law,
Okay.
in conformity with good corporate governance.
Yeah. We have
If you
heard
want to
people-
sack somebody, go through the laid down
Right.
procedure.
We have heard people raise issues, for example, about the Director General of the Ghana Health Service, because his tenure has been extended, and people are saying he's over 65.
Yes.
And where are you bringing him from? Anyway, all right. Yes,
Well,
Kweku.
I don't have much to add to what has been excellently articulated here. Indeed, I've been reading the judgment, but based on what has been said here, I think I'm better informed and more educated. But the last point about the age thing, I've just gone back to the Hansard during the proceedings. This was 29th October 1996. Clause 8, Article 199, compulsory retirement for public service. And I'll read that part.
Okay.
It says this amendment seeks to add a new subclause to Article 199, which will enable the appointing authority to engage some retired officers with specific expertise. Article 1991 provides for compulsory retiring age of public officers at 60. However, the realities of the situation, as stated in the memorandum accompanying the bill, is that some services can ill afford to dispense with services of some retiring officers with specific expertise. This provision is not new because it is already provided for under Section 72 of the Civil Service Law, PNDC Law 327. The amendment is only seeking to give it a constitutional recognition. Your committee, however, cautions that the policy framework behind this amendment should be seriously enforced, namely, the appointing authority should ensure that those to be engaged are those who have specific expertise and technical know-how, which cannot be easily replaced. This is necessary in order to avoid the abuse of this dispensation.
Wow.
And
but
this
it doesn't answer one question.
That's the most important point. That's the most important point.
And this was upheld unanimously.
There's a part you read,
But abuse.
which talks about retaining. There's a part.
Yes.
Retain.
Can you read that part
Yes.
again?
Yeah.
That's about retaining.
Yes.
There's a part.
Some of the public offices
retain it.
cannot retain.
Yeah.
Yes.
You see,
No.
There's a
Cannot-
part you read.
And I'm looking for.
he read it. He read
The
it.
most important
Yeah.
part, the most important part for me is the specific expertise and technical know-how which is relevant to the office in which the person is being appointed. Now, your insistence is that he must be coming from that outfit. That's not my reason of this.
Not specifically. The question
not
he's asking.
necessarily from within.
The question he's asking is not specifically that he must be coming from that outfit.
You know,
where, for example,
Honorable is insisting on retaining, the word
yes.
retaining.
There's a part. There's a part that's
So that's where you say it doesn't wash.
Yes.
So you are saying that if Randy
Yes.
was in a particular public office and attained 60, then he went on retirement.
maybe this way
He was not retained immediately. He went on retirement. He attained 65.
So
he can still go back
retain.
to that office to work
That's the
on a contract.
That's what I'm saying. That let's separate this.
That's what people want to resolve.
No, this is the age issue, but it's not about the specific expertise issue, and the need to get somebody into an office. And this is cross. When I say cross, it means that you are from an institution A to an institution B. If you insist on retention, it means that once you retire from institution A, then you must necessarily go back to institution A, even if you have specific expertise for institution B. That's not the reading of the provision for me, especially when Kweku read out the hindsight, the argument, the policy rationale for it. So I would say that compulsorily you go at 60. Let's say you go at 60, and you are from institution A and there's institution B where you have specific expertise, and that's the test. That's the threshold. That is the threshold. Whether or not you have specific expertise.
Chief, the problem is that the problem actually.
Just read it again and let's go.
Yeah.
Just read that
You
portion.
see,
Let's go.
that is on paragraph. No, which one is this?
That's the Hansa. That's the Hansa. That's what you're looking at.
Okay. So that is this amendment seeks to add a new subclause to Article 199, which will enable the appointing authority to engage some retired officers with specific expertise. Article 1991 provides for compulsory retiring age of public officers at age 60. However, the realities of the situation, as stated in the memorandum accompanying the bill, is that some services can ill afford to dispense with services of some retiring officers with specific expertise. This provision is, however, not new because it is already provided for under Section 72 of the Civil Service Law, PNDC Law 327.
It will be relevant to go look at that 72.
Your committee, however, cautions that the policy framework behind this amendment should be seriously enforced. And what is the policy framework?
Yes.
That is only retiring officers with specific
expertise.
In fact,
that's what I'm saying.
the answer goes on.
Okay.
This answer,
That is the test.
It goes on to say something, and that's the big question I want to ask. And that is perhaps something which is lost on all of us.
30 seconds.
It talks about technical
Know-how.
and know-how something.
Yeah.
So
And
it talks
specific
about
expertise.
a policy framework.
Yes.
And it talks about technical, specific technical
That cannot be
Specific-
easily.
that cannot be easily. So one, does that policy framework exist? And two, have the appointing authorities over the years provided this particular technical and
The policy
No,
framework
the
was
political
captured in the memo.
memo.
yes. No, but I'm saying
Randy,
that have we had a conformity to that?
Randy.
No,
if
but
you
it's
are
been
a
abused.
ballistic-
Yes.
Yes,
Because it says that it is to avert the abuse.
Yes, but we have abused
We have
it.
not.
We have abused
You have
it.
abused it.
Okay.
Now, for instance, if you are within the Ghana Police Service,
Yeah.
and you are the ballistic expert, and for over the years we have not trained a person to replace you, that could be the specific expertise that you have might enable us extend your retirement age.
Even when you get to
But
60,
if you are an IGP, you don't need any specific expertise.
Okay, I
to be
see
an
your
IGP.
point.
The lawyers here
that's
clearly
fine.
That is why at the universities,
that
it
is
is
good.
very
Yes,
easy,
that-
commonly
that
practiced in the
point is
universities.
very good.
For the professors who
the
are
lawyers here
retired.
help me.
Okay, wait, let's take a break.
The lawyers here
Let's
help
take a
me.
break.
No,
By
it's
virtue
the
of
university
I think we
By
can-
virtue
we
of
can
this-
terminate it here.
By virtue of
Thank
this,
you. We'll
by
end it
virtue of
here.
this.
We'll return to deal with other matters, including breach of your data by the Electoral Commission. The Auditor General says so.